Good evening, Mr. James. Do you want to, would you please introduce yourself to the court?
Sure. The name's James. Jordan James.
Mr. James, what do you do?
I'm a musician. I play a very unique variety of folk country. Of course, I haven't made my big break yet, so until I do, I bartend at Chuggy's.
And why are you here today?
Well, I was the bartender that was on duty on the night that that awful accident happened.
Mr. James, how well would you say you know Mr. Dust?
I would say that he and I are pretty good friends. Known each other for about a year and a half now. We talk all the time, and we were even on a softball team together.
Have you seen him at the bar?
Yeah, he comes in pretty frequently. Comes in, hangs out with me, has some drinks with me, and we talk all the time.
From your perception, Mr. Dawson, what kind of person is he?
He's one of my favorite customers to have around. Danny's really nice to me. He's really nice to everybody else. He's never belligerent. He never starts any fights. And he always takes really good care of me when it comes to tipping time.
And how much alcohol does Mr. Dawson typically buy from the bar?
Well, Danny will come in. He'll buy drinks for all the girls in the bar. He's always having me buy a round of shots for everybody. On a typical night, he'll buy $100, $125 worth of alcohol and maybe have drank actually 2 or 3 drinks.
And would Mr. Dawson have driven drunk?
Objection, Your Honor. It's a leading question.
Sustained.
In your interactions with Mr. Dawson, have you known him to drink drunk?
Objection, Your Honor. Improper character evidence.
Your Honor, according to Rule 404A1, the character of the accused, in this case Mr. Dawson, is an exception to the character evidence.
Should I respond? The court has actually ordered before the trial, and they ordered on motions in limine on page 5, that the defense is required to submit a notice before trial indicating that they are going to be presenting character evidence.
What page is that on?
Page 5, number 1.
Did the defense provide any notice to the government?
There, Your Honor.
Seeing that that's a violation of motion from the government, sustain that objection.
Yes, Your Honor. In that case, let's specifically talk about what happened the night of the accident.
Sure.
That night, Mr. Dawson, when did he come into the bar?
He came in earlier in the afternoon. He had just had a job interview there, and he didn't have a ride back because his aunt had drove him, so he came to hang out in the bar for a little while.
How was he acting?
I mean, he was acting like good old Danny, like I'd always known him. Danny's always really friendly with everyone. He's always dancing with people, being silly, being goofy. That's just what he's like.
How much alcohol was he drinking?
You know, when I think of it, that night he was drinking a lot fewer drinks than he normally does.
Objection, Your Honor. Improper character evidence.
I'm going to
Once again, how much alcohol did he seem to be drinking that night?
A lot less than he normally does. He was taking it really slow that night.
And was he acting sober that night?
Yeah, I mean, I'm a bartender, so I'm around drunk people all the time, like way more than I would care to be. And he definitely was not one of them.
How could you tell?
I mean, he was acting totally normal. He wasn't stumbling around or slurring or being way over the top goofy or anything like I usually see in drunk people.
Additionally, when you left your bar, did it appear to you that he was able to drive a car?
Definitely.
Objection, Your Honor. Speculation.
Your Honor, in Rule 701, it says that if the witness can make a conclusion based on his rationally based perceptions, it is admissible in the court. He's a bartender. He's seen people get drunk at his bar, and he can make that conclusion based on his experience.
Hopefully this is something that this witness can rationally observe and testify to.
I'm going to sustain the
Once again, how was Mr. Dawson acting when he left the bar?
He was completely fine. It's part of my job to stop people from driving. If I have any reason to believe they shouldn't be getting behind the wheel of the car, I wasn't worried about him at all.
Thank you, Mr. James. Pass the witness.
May I proceed? Mr. James, you mentioned on the direct that you're a bartender, is that correct?
That's right.
I'd like to talk to you about how bartenders make their money. You rely mainly on tips to make your money, is that correct?
That's right.
And you actually have regular customers that account for a lot of your tips?
Yes, definitely.
Objection, Your Honor. This is not relevant.
The line of questioning seeks to establish a familiarity between this bartender and the defendant.
If you can get there quickly.
Very well. One of your regular customers is Danny Dawson, is that correct?
Yes, that's right.
Now, in the time that you've known Danny Dawson, he's tipped you over $2,000, is that correct?
Yeah, I'd say that's a pretty good estimate.
And this is the same defendant that you mentioned was going to a job interview.
He had a job interview earlier on the day that accident
A job interview that didn't go well.
No, he told me that he kind of fumbled it a little bit. Happens to the best of us.
I'd like to talk about what happened after he on that interview. You mentioned that he came to the bar early that afternoon,
Yes, I believe it was around 2 in the afternoon was when his interview was finished.
and it was about this time that the defendant began to drink.
Yeah, we had a few drinks earlier that afternoon.
Do you remember what time the defendant left the bar that evening?
Yes, it was about 12:45 p.m. Was when he headed out the door.
I'd like to talk to you about what happened in between that time. Now, that was a busy night in the bar, is that correct?
Yeah, that's right. There was this band, this real popular band playing, and so we were packed to the brim.
You were actually having trouble filling all the drink orders that were coming into you.
That's right. I was running around like a chicken with my head cut off that night.
So you actually had some difficulty remembering all of the details of that night, is that correct?
Yes, that's true.
I'd like to talk to you about some of the things that you do remember. Now, you remember when Danny Dawson came to the bar with a friend.
That same day, he was actually there before his friends. His friends came a little bit later, but yeah, he had actually a couple of friends with him.
Okay, let's start with what you observed while he was there before his friends got there. Do you
Okay.
remember how many drinks he had during that time period?
I believe it was 5 or 6 earlier that afternoon, within the span of the 4.5 hours or so.
And then after his friends arrived, when he went to the bar with one of his friends, you served them both a shot and a beer, is that correct?
That's right.
Now, later in the afternoon, do you recall hearing an argument between the defendant and Taylor Hobson?
Yes.
Remember Taylor Hobson saying,
Objection, Your Honor. This is hearsay.
this doesn't go to the truth of the matter, sir, if I may make a proof or an offer of proof.
Please.
All Taylor Hobson is asking is whether or not the defendant is okay to drive. For the truth, it's not any, no truth is being asserted in that statement, it's just a question.
Your Honor, this trial is investigating whether or not Mr. Dawson was driving under the influence. Asking whether or not Taylor Hobson thought he was ready to drive is for the truth of the matter.
I'll sustain the objection.
In this argument that you witnessed between the defendant and Taylor Hobson, do you recall what the defendant said?
Vaguely.
Do you recall what the defendant said, that he was okay to drive?
I think he said that.
Do you also recall the defendant saying that he would make it home in record time?
Yeah, that's right.
No further questions.
No recross, Your Honor.
Good evening. Will you please introduce yourself to the jury?
Yes, my name is Dr. Ashley Norton.
Dr. Norton, why are you here today?
I was asked to take a look at the breathalyzer results that were performed on Mr. Dawson on the night of his accident to determine whether or not they were valid.
How are you qualified to test the validity of breathalyzer results?
Well, I got my master's and my PhD from Johns Hopkins in forensic science. I've been a professor of medicine here in Midlands pretty much since I graduated. My focus is in alcohol pharmacology. I've worked with all manner of breathalyzer machines, including the most current, the Alcoholizer 8000, which is the machine that the Midlands Police Department uses.
Is that the same machine that they used in this case?
Yes, ma'am, it is.
Well, what did you need to look at to determine whether or not the test done by the state was valid?
Well, I needed the test that the state did perform, the results that they had, and then I needed to speak to the subject, in this case, Mr. Dawson, to confirm a timeline of what he ate and drank that night.
Were you able to do all of that?
Yes, ma'am, I was.
All right, so once you get all of that information, how does that help you find out whether or not the test was valid?
Well, what I do is I put the test results aside for a moment, and then I work backwards with this formula that's been around basically since my field was invented. It's a formula by Dr. Woodmark. And I'll take what the subject, in this case Mr. Dawson, told me, and I'll work backwards based on how many drinks he told me he had to determine what his blood alcohol content should have been.
Were you able to reliably use that formula in this case?
Yes, ma'am, I was.
Were you able to determine whether or not the test that the state used was valid?
I was.
Well, doctor, was that test valid?
No, ma'am. It exaggerated the blood alcohol concentration of Mr. Dawson when he was driving.
If it's a machine, how can it exaggerate a number?
These breathalyzer machines are helpful. They're very helpful tools. But like any machine, they're not perfect. They make mistakes. In this case, the biggest problem is that they will mix up, I guess what you can call bar alcohol, which you drink, and then body alcohol, which is alcohol that's produced naturally in your system.
Well, I think most of us know what bar alcohol is, but what's body alcohol?
Believe it or not, there are a lot of processes in the human body that naturally produce alcohol. Alcohol enzymes, pathways for these enzymes to proceed. If you take a breathalyzer test, some of the alcohol that's just naturally in your system, it's not the kind that makes you intoxicated, will be read by the machine. It can't tell the difference.
Why can't the machine tell the difference?
Well, think about it this way. If you stand on a scale and you hold two 20-pound weights in your hand, the scale is going to tell you that you weigh 40 pounds more than you do. It can't tell the difference between yourself, how much you weigh, and the two 20-pound weights. It's just measuring everything in a field. It's the same with the breathalyzer test.
Well, do you have any reason to believe that Mr. Dawson may have had some of that body alcohol on the night he took the test?
Yes, ma'am. I believe Mr. Dawson had what we call mouth alcohol, which is some of that naturally produced alcohol in your body. You take that big deep breath, you blow into the breathalyzer machine, some of that body alcohol goes with it.
Well, how would someone get mouth alcohol?
There are a lot of ways. Some of the external sources, gum, mouthwash, things like that. Internally, burping, vomiting, and acid reflux, or the symptoms of acid reflux, which are heartburn.
So if all of those things can cause the machine to give you an inaccurate result, how do you make sure the test is right?
It's difficult. The observation period is very important. If individuals know that burping can mess up the results, they will intentionally start to do that. That's something that we can see. We can see someone vomit, we can see someone burp, we can see someone have gum or mouthwash. It's a little bit more difficult with heartburn. It's not something you can as readily observe.
Do you have any reason to believe that Mr. Dawson may have had heartburn?
I do. Mr. Dawson informed me that he ate a large burger, an extra large order of cheese fries, and coleslaw for dinner, and then he had some heartburn.
If Mr. Dawson had heartburn, how would that affect the test?
Mr. Dawson would have had that mouth alcohol, that body alcohol present in his system, and he took that big deep breath to test his alcohol concentration. Some of that would go with it, meaning that the machine would overestimate how much Mr. Dawson's blood alcohol concentration was that night.
What does that mean for the results that the state got when they conducted that breath alcohol test?
It means that their number was simply too high.
Pass the witness.
mentioned using the Winsberg and Strasberg, the formula.
The Widmark equation? Yes, ma'am, yes.
And you use 5 factors when estimating the blood alcohol concentration.
Yes, there are 5 factors.
Now, one of those was the total alcohol consumed.
That's right.
And to get that, you have interviewed the defendant, Danny Dawson.
I did.
Now, you did not corroborate with that, did you?
No, ma'am, I spoke to Mr. Dawson solely.
So if the defendant had lied to you, your findings would be incorrect.
Mr. Dawson told me he had more or less drinks than he did. My formula would be slightly off, that's right.
Now, you mentioned you estimated a timeline. Let's walk through that. From 2 to 6, he had consumed around 4 alcoholic beverages.
Yes, ma'am.
Then from 6:30 to 12:30 a.m., he consumed about 5 alcoholic beverages.
Yes, ma'am, that's right.
Now, you assume that the standard of alcohol in each drink was the same.
Yes, we assume that there are 14 grams per alcohol, which is the standard that bars are expected to pour by the TABC.
Now, if that standard, if the drinks were stronger or weaker that night, then your conclusions would be inaccurate.
They would be skewed, that's right.
Now, earlier you mentioned the body alcohol. You're familiar with the Intoxifizer 8000.
Yes, I
In
am.
fact, you're an operator and a technician of this.
I am.
Now, you're familiar that the machine is actually very good at screening out those body substances.
It's one of the better models, yes, but it's not perfect.
And with the mouth alcohol, Danny Dawson did not burp. Is that correct?
He was not observed to burp, that's right.
And he did not belch.
I do not believe so, no.
And he did not consume any mints prior to the test,
No, that's right.
or consume or use any mouthwash. Is that correct?
That's right. No external sources of mouth alcohol were present.
Now, with your conclusion, you suspected that the standard of alcohol was actually different. Is that correct?
I'm sorry, the standard of alcohol?
The standard that you used, the 14 grams, was different than what you used for your conclusion.
I'm sorry, you lost me again. The standard that I use, the 14 grams is what's standard, what we assume
And you
all drinks
suspected
are.
that the drinks were actually stronger.
I believe it was a possibility, yes.
So your findings, again, would be inaccurate.
They would be skewed, they would not be inaccurate.
So even though you suspected that it was stronger, you still used that standard.
Yes.
Now, even after all these efforts to determine the validity of the blood alcohol concentration, you still found the defendant to be drunk that night.
I believe that Mr. Dawson's blood alcohol concentration would be around the legal limit, which is 0.08.
And that would still be considered to be drunk.
It would be at the legal limit.
Now, you also stated that the defendant might not have had any effect, or had much effect, as to what
Effect
of what he was doing.
well, I'm sorry, I don't understand your question.
All right, let me rephrase the question. Now, with that limit, the 0.08, there is a impaired judgment. Is that correct?
Yes.
Passage.
No further questions, Your Honor. May Dr. Norton step down?
The defense calls Leslie Romney to this thing. Good evening. Could you introduce yourself to the court?
Yes, my name is Leslie Roman.
Ms. Roman, what do you do?
I'm an accident reconstructionist in the city of Midlands.
What's an accident reconstructionist?
I work backwards to find out what happened during an accident.
How are you qualified to be an accident reconstructionist?
I have a Bachelor of Science degree from the University of Texas. I work for the Midlands Center of Transportation, and currently I own my own firm.
How are you involved in this case?
I was hired by the defense to see what happened during this accident.
What do you look at the beginning to put together an accident, to reconstruct it?
I look over the witnesses' testimonies. I go to the scene of the accident to see what happened there. I look at the damage done to the car and read over the fatal crash team's report.
And did you do that in this case?
Yes, I did.
Once you've gotten all this information, then what do you do with it?
After that, I apply principles of physics and plug these all into equations to figure out just what happened that night.
And where are these found?
These are found in the Windsor and Strasbourg article.
Is that trusted and respected in your field?
Yes, it is.
In this case, did you reliably take the information that you gathered and the principles of the Windsor and Strasbourg primer, and did you do that accurately for your conclusions?
Yes, I did.
I'd like to talk about your conclusions. What happened in this accident?
What happened in the accident?
Objection, Your Honor, calls for narrative. Your response.
Your Honor, I just asked a simple question as to what happened in the accident. She's an accident reconstructionist.
I think I'm going to rule that.
What happened that night? The weather conditions were bad. It had been raining heavily. It was at a dark point, dark time at night. It was on Canyon Road, and what happened was that the defendant was driving on Canyon Road. A suddenly appearing obstacle appeared on that road. Danny Dawson swerved, went off the road, went back on, and then hydroplaned, and then hit a utility pole, and then a tree.
Now, at the beginning, you talked about a suddenly appearing object. What's a suddenly appearing object?
A suddenly appearing object, usually they're animals. In this case, we believe it to be a deer.
Where did this deer come from?
This is a very heavily wooded area. The deer could have come from either side of the road.
How do you know that there was a suddenly appearing object there?
We know that there's a suddenly appearing object there because there are tire tracks on the road and on the grass, and all these tire tracks indicate that Mr. Dawson swerved in that movement is consistent with avoiding a suddenly appearing obstacle.
After Mr. Dawson swerved, what happened next?
After he swerved, he was along the shoulder of the curve. One wheel was on the grass, one wheel was on pavement. He went 124 feet like this. He managed to regain control and get back on the road. But then, because the road was watery, he hydroplaned and slid across the road to hit a utility pole and then a tree.
After he got back on the road, you said he hydroplaned. How can you be sure that he hydroplaned?
Well, the marks on the road, there were no marks on the road, in which case this indicates that there was a film of water on the road, which causes the car to kind of slide across the surface.
And if someone does hydroplane, do they have any control over their car?
They have no control over that car at all.
You said that it hit a tree and a utility pole. Where was this tree?
This tree was only 2 feet away from the edge of the pavement, and usually trees don't grow this close.
Why don't trees usually grow this close to a road?
Usually the city will cut down trees in the roads to allow the driver a margin of error. In case they go off the shoulder, it's that empty space for drivers to go.
Now, Ms. Roman, I've been driving before and I've seen trees that close to a road. Is there anything else that road constructionists will do to protect a driver from trees?
Yes, what all should occur there is a guardrail.
If there had been a guardrail there, or if this tree wasn't there, what might have happened in this accident?
Objection, Your Honor. Rule 407 looks towards subsequent remedial measures taken by the state. Do you have another response?
Under Rule 703, I'm asking an expert witness. I'm presenting her with new data and asking her to make an expert conclusion on it. That's what I'm doing.
Your Honor, I understand the rule. However, Rule 407 states that any evidence offered to prove that the event would have been less likely to occur is exclusively prohibited under the rules of evidence.
Your Honor, that goes to civil cases that says that, for example, if someone's on a ladder that's with a slick thing, with a slick ground, the ladder falls, and then they clean up the water. Cleaning up the water doesn't show negligence. That rule's made for civil trials.
Your Honor, this is not applied exclusively to civil cases.
What rule was that?
Rule 407's permission to approach and,
They have a copy.
You can approach.
oh, they were, and this is indeed a line of questioning that addresses that with the exclusive intent to show that this event would have been less likely to occur.
Your Honor, first of all, I didn't, although it is true that they were extended, I never did ask her about that. I was just asking if it did, if it were there. And second of all, this rule is made to protect the party that is being, to protect the defendant. Like a city, we aren't suing the city of Midland. We're not saying that the city of Midlands is liable for this accident. We're just trying to show that this may have been a dangerous situation. We're not trying to shift blame to the city.
Counselor, if you can go ahead and rephrase it more in the form of a hypothetical, and Counselor, you're free to object again if you'd like.
So,
I'm going to sustain your objection, and I'm asking the Counselor to rephrase the question, and you feel free to object again if you'd like.
Rephrasing. And rephrasing to a hypothetical, you said?
Yes.
Hypothetically, if there were to have been a guardrail there, or if a tree had not been there, what might have happened?
I can't say for sure, but this accident would not have been that bad, and Vanessa Sullivan might be alive today.
No further questions.
never see? Ms. Roman, you certainly did do a lot of testifying as to a deer being in the roadway at the time of the accident, true?
I said that it was consistent with a deer being in the road.
Okay, so the signs are consistent with a deer being in the road. Isn't it true that you are in no position to determine conclusively whether a deer was in the road?
Because I wasn't there at the scene of the accident, I can't say conclusively there was
All right.
a deer.
And your work in this case was limited to just accident reconstruction, true?
Yes.
All right. During your time at the accident reconstruction site, did you ever see a deer?
At the site,
Yes.
there was a deer crossing sign 1 mile south.
Maybe you misunderstood the question. I'm asking, did you personally ever see a deer at the time you were at the accident reconstruction site?
When I was at the accident, I did not see a deer.
Okay. And just to be clear, you weren't there during the accident.
No, I was not there during the accident.
Okay. Isn't it true that the defendant could have swerved for any number of reasons?
But his swerving was consistent with that of avoiding a deer.
Maybe you misunderstood the question. I'm asking if he could have swerved for any number of reasons.
There could have been other possibilities, but this one is
All right,
most likely.
let's talk about some of those possibilities now. Could there have been perhaps a rabbit in the roadway?
An suddenly appearing animal, I think it was a deer,
Okay.
because a rabbit is an extremely small animal.
Well, could the defendant simply swerve because he lost control?
He lost control because he swerved, and his swerving is consistent with the suddenly appearing obstacle.
Could the defendant have swerved because he was intoxicated?
No.
So it's your testimony today that swerving due to intoxication is not a possibility in this case.
I am saying that his swerving was consistent with the animal in the road.
Okay. I'd like to talk about your report that you made as to the accident reconstruction. You testified earlier that you relied on a Windsor and Strasbourg primer for your conclusions?
Yes.
And in that primer, you used an energy speed equivalent formula, correct?
Yes.
And the primer dictates two different formulas depending upon the circumstances.
Yes, either the car hit a narrow object or a wide object.
Okay, and that primer dictates a narrow object to be less than 24 inches in diameter, correct?
Yes.
And a wide object to be greater than 24 inches in diameter, correct?
Yes.
Let's talk about that. When you visited the scene of the accident, you took measurements of the tree that the car had collided with, correct?
Yes, as well as the utility pole.
And the diameter of that tree was 39 inches, true?
Yes.
Would you say 39 inches is greater than 24?
Yes, it is.
All right, however, you use the formula for the narrow width object.
The car first struck a utility pole, which is less than 2 feet wide.
I'm asking, did you use the formula for the narrow width object on the passenger side of the vehicle that struck the tree?
Yes.
Okay. And you had just testified earlier that you would only use that formula when it collides with an object with a diameter of greater than 24 inches.
Yes.
So you used the wrong formula.
I use the right formula.
I'd like to be clear here today. This energy speed equivalent formula gave you a number, correct? A speed?
Yes.
And you use this speed and the combined speed formula to calculate the car's initial speed at the time of the accident, true?
Yes.
So if the speed you calculated from the energy speed equivalent formula was wrong, then your combined speed formula would be wrong as well.
If I were wrong, yes.
All right. Now, part of being an expert is to remain unbiased in your conclusions, correct?
Yes.
But isn't it true that you took this case to make sure the state was not blinded by the need to blame?
You typically only take cases for defendants because the state...
Ms. Roman, maybe you misunderstood my question. I'm asking simply, did you take this case to make sure that the government was not blinded by the need to blame?
Yes, that's pretty important.
No further questions, Your Honor. Pass the witness.
No further questions. We ask that the witness be let step in. And with that, the defense rests its case in chief. We ask for a short recess before closing statements.
How long would y'all like?
Could we request 10 minutes?
10 minutes?
10 minutes is fine. 4 minutes.